There was a time when our hair was regulated by colonial law. Later, it was regulated by social norms. Today, it is entering a digital age, shaped by intellectual property and copyright law. This time, the regulation is coming from within the community itself. A legal dispute over a hairstyle marks that shift, not because of the style, but because of the precedent it may set and what it signals for the future.
So far, we've received 2 copyright strikes on our YouTube channel, multiple video takedowns across several of our social media platforms, 2 DMCA reports filed against our Kickstarter campaign, a cease and desist letter,
and now a federal lawsuit. All of this is happening because an entity is trying to legally own hairstyles, or what we like to call hair sculptures.
What I do across all my platforms isn't hairstyling, it's sculpting. I use my natural hair as a medium to create art sculptures. The same way a painter uses paint and a sculptor uses clay, I use my natural hair. Under U.S. copyright law, sculptures are recognized as protected forms of art.
Picture a city where people wear dresses every day. Different colors for different moods. Blue when they feel calm, black when they want to be serious, and red when they want to feel bold and confident. No one owns dresses, and no one owns color. Then one designer builds her entire identity around a specific red dress. The same silhouette, same details worn repeatedly and marketed consistently. Over time, people begin to associate that red dress with her name. Eventually, she says, "This isn't just a dress anymore. This is my brand." Her future depends on that recognition. Her income depends on it. She builds stories around it, characters, products, and a vision she wants to protect. But then she notices others wearing red dresses too. Not the same cut, not the same labels, just red dresses worn freely, the way they always have been. The argument isn't about who invented dresses, and it definitely isn't who invented red. The argument becomes something entirely different. Can one person claim a shared visual language as a protected identity once survival depends on it? Once it becomes a business? The question may sound simple, but it really isn't, because this is the tension now playing out through here. The term hair sculpting may sound modern, but the practice itself isn't. At its core, hair sculpting is a deliberate shaping of hair into structured, three-dimensional forms. Not just simply styling for neatness or beauty, but shaping where forms carries meaning. Long before the term existed, the practice did. In Central African societies, sculptural hairstyles were used to express identity and belonging. Hair was shaped into forms that emphasized volume, symmetry, and geometry. Art historian Roy Sieber, writing in African Art, observed that European viewers often describe these styles as decorative, not because they were ornamental, but because they lacked the cultural framework to read them. What appeared as ornament to outsiders functioned as communication within the community. Further north, in the Nile Valley, hair shaping was formalized even further. Egyptologist Gay Robbins documents how wigs and sculpted hair forms operated as regulated expressions of status, priesthood, and ritual purity. These were not personal choices, they were codified systems. Hair signaled role, rank, and readiness long before written credentials existed. Across these regions, the purpose was very consistent. Hair sculpting was not about standing out, it was more so about being recognized. The shapes mattered because the community understood what they meant. No one needed to explain them, and no one person claimed ownership over them. These practices were learned, repeated, and passed down. They belonged to life stages, social roles, and collective identity, not to individual creators. It is important to be precise. In many African societies, hairstyles operated within shared cultural rules. But shared cultural rules are not the same as ownership. Hair functioned much like language or dress code. Certain expressions were appropriate in certain contexts. Others were reserved for specific moments or roles. A uniform does not belong to the person wearing it. A language does not belong to the person speaking it. And hair basically followed the same logic. You did not own the form, you were authorized to wear it. When our ancestors were displaced, it was not just about the loss of their geographical location. It was structure, their existence blueprint. The systems that governed meaning did not survive. Elders, rituals, and communal enforcement were fractured. Hairstyles that once operated within clear social rules were carried into environments that did not recognize those rules. In Western societies, culture does not circulate primarily through inheritance. It circulates through ownership, and we've all seen this before. For example, music once moved freely through communities. Melodies were learned by ear, repeated, adapted, and passed down. Folk songs belonged to regions, not individuals. No one needed permission to sing a tune that they inherited. Over time, however, that changed. As copyright law developed, songs became assets. Melodies became protected works. Participation gave way to licensing, and sharing became regulated use. Music did not disappear, but it learned to circulate through ownership. The same shift is now being negotiated in other forms of cultural expression. Value is assigned through authorship, protection through exclusivity, and survival often depends on converting expression into commodity. This is the logic of capitalism. Under this system, what cannot be owned cannot be reliably protected, and what cannot be protected struggles to generate sustained income. As Black communities adapted to the Western capitalist structures, cultural practices were forced to change their function. Hair that once signaled belonging became something to manage, to justify, and eventually to monetize. Over time, expression became opportunity. In the digital era, this shift accelerated. Visibility turned into currency, recognition became income, and cultural expression began circulating at scale. This essentially created pressure. In a system where attention is unstable and imitation is fast, creators learn quickly that what cannot be formalized can be displaced. What cannot be defined can be overtaken. So, here, culture adapts again. Shared visual language becomes personal brand. Communal forms becomes signature look. And expression becomes product. At some point, abstract tensions become concrete. They take shape around real people, real work, and real livelihoods. In this case, the tension appears around two creators working within the same visual language of sculptural hair. One creator approaches this language through long-term world building. She describes developing a character for a children's book, visually defined by distinct sculptural hairstyles. In her framing, the hairstyle is not a standalone look. It's a part of a larger creative identity she's trying to formalize and protect. Her concern is not simply imitation, it is displacement. In a system where recognition translates into income, losing control over a recognizable visual identity can mean losing the future attached to it.
Creative integrity and protection are a big part of what I stand for, and I want to take a moment to help people understand what that means, especially when it comes to my hair art sculptures. What I do across all my platforms isn't hairstyling, it's sculpting. I use my natural hair as a medium to create art sculptures. The same way a painter uses paint and a sculptor uses clay, I use my natural hair. Under US copyright law, sculptures are recognized as protected forms of art. So when I say my art is protected, this is what I mean. And to make this super clear, let's ask Google a couple questions together. Are sculptures protected under copyright law?
Yes, absolutely. Sculptures are a class of work specifically protected by copyright law around the world. The U.S. Copyright Act includes sculptures under the category of pictorial, graphic, and sculptural works. This includes two-dimensional and three-dimensional works of fine and applied art. For a sculpture to be protected, it must 1. Be an original work of authorship. It must be independently created by the author and possess at least a minimal degree of creativity. 2. Be fixed in a tangible medium.
Is hair considered a medium in art?
Yes, hair is absolutely considered a medium in art. It is used by artists, both historically and in contemporary practice, as a tangible material with deep symbolic meaning.
What is considered a sculpture?
A sculpture is fundamentally defined as a three-dimensional work of art.
So by every legal and artistic definition, what I create are art sculptures. I also work with 2 separate intellectual property attorneys who confirm this and assist me in protecting my artwork. Now, copyright protects the art itself. When I name my sculptures, that's where trademark comes in. Lastly, let's talk about something called trade dress. Trade dress protects the overall visual appearance and design elements of a brand's image or product, the things that make it instantly recognizable to the public. So when you see these distinct sculptural forms like this or this, you automatically recognize it as me and my brand without even seeing my face. That's what trade dress does. It protects that unique visual identity. For the record, my work has been viewed over 500 million times across all platforms, so thank you for the support over the years. Trade dress is another layer of intellectual property protection, just like copyright and trademark, and it's what keeps the visual integrity of your brand safe. Having my intellectual property infringed upon, especially when it's my work and my natural hair, is very personal. My art is a direct extension of me. So when that work is used or imitated without my consent, it doesn't just feel like creative theft. It feels like a violation of my personal autonomy, something that is being used without my consent. This is why I created the Queen Culture Foundation, to educate and empower other artists to understand how to protect what they create. Too often, originality gets overlooked or imitated, and the artists aren't taught how to defend their work. The foundation is about changing that through education, advocacy, and preserving creative integrity. What I will always do, and what you should do as well, is protect my intellectual property and continue honoring the art that I built. I will not be bullied out of protecting my work, especially as a culture, because we understand how often our creations are taken from us, uncredited, or erased. And what makes this situation even harder is that I'm experiencing this within our own culture, the very space that I've always aimed to uplift. Before I go, I want to make something clear. Each platform has its own process for handling infringement, and they make their own independent decision on how to deal with accounts that violate intellectual property rights. As the artist, I have no control over these outcomes. All I can do is report infringement to have the protected work removed, provided they prove ownership. From there, the platform reviews the evidence and determines whether infringement occurred. If the platform identifies a user as an offender, it's their decision alone on how to handle that account. It's been an exhausting experience having to protect my work, but I'll never stop creating, teaching, and standing up for what's right. If you're an artist, I hope you learn from this too. Protect your work, value your originality, and remember there's always room for you to create something that's truly yours.
The other creator approaches the same visual language differently. She argues that sculptural hairstyles did not originate with any one person or project, that they existed within African and diasporic traditions that predate modern branding. From her perspective, shaping hair into structural forms is cultural continuation and not creative infringement. I must note that she also manufactures and sells sculptural hair extensions inspired by the same visual language.
If we don't speak up and continue to stand up for ourselves, we believe that what's happening to us right now can potentially happen to other creatives who decide to enter the natural hair sculpting niche in the future.
So far, we've received 2 copyright strikes on our YouTube channel, multiple video takedowns across several of our social media platforms, 2 DMCA reports filed against our Kickstarter campaign, a cease and desist letter,
and now a federal lawsuit. All of this is happening because an entity is trying to legally own hairstyles, or what we like to call hair sculptures. So today we're going to be breaking down everything that has happened to us this far and why protecting this niche matters more than ever. Around late 2023, I went viral for recreating a natural hair sculpt that I saw from a photo that was taken back in 1971. Natural hair sculpting has been a thing way before the 70s as well. It's older than all of us. So ever since then, I've continued the practice, and then I ran into a few problems that I wanted to solve, like how can I save time doing hair sculpting? I also wanted to make the practice more accessible for the children specifically. It's really important to me that the children see the beauty in their natural hair textures early, and I know that even if their parents were able to sculpt their hair, it may not last all day, or it's not something that they could just practice all the time. It doesn't last. It's a high maintenance practice, and so that's why I came up with the Solar Beam sculpted hair extensions. So to prevent this video from being copyright striked, I don't want to add any pictures of my sculptures. The children look cute as you can imagine, and so did my adult models. So obviously running a small business is a lot, and if you're an entrepreneur, you already know that it takes serious time, energy, and money. That's when we decided to launch a Kickstarter campaign, but to grow our business, improve our production, and to make more art. And that's when things started to get really weird.
DMCA stands for the Digital Millennium Copyright Act. It's a US law that was passed in 1998 to control how copyright works on the internet. So basically, anyone can say, I own this copyrighted content, someone posted my work without my permission, please remove it. And here's the part most people don't understand. The entire system relies on claims, not proof.
So on the same day that our Kickstarter completed, on May 12th of this year, 2025, I received an email. It was from Kickstarter, and it was telling me that a DMCA takedown request was filed. And as they usually do, they send you the claims that were submitted, and this is what was said in the letter.
My client is the original creator and brand owner of a distinctive visual identity centered on Afro hair designs styled into unique shapes such as hearts, stars, and flowers. This aesthetic is a signature of their content.
Now, this is what we understood after reading this part. They're insinuating the idea that they have invented the look or the concept of sculpting these shapes into their hair, and that these hairstyles belong to them as a part of their brand identity. They're saying that these shapes are their signature, and therefore anyone else who creates these similar shapes is copying their aesthetics.
And this detail matters because once cultural expression becomes a product, the question starts to shift. It's no longer about history or inspiration. It becomes about markets, visibility, and substitution. This is not a debate over who invented a hairstyle. It is not a dispute over ancestry. It is, however, a disagreement over how shared cultural forms behave once they are formalized into brands, characters, and products. Both positions make sense within the system they are operating in. Before we go any further, one clarification is necessary. I am not a lawyer, and this is not legal advice. What follows is not a legal ruling or an argument for either side. It is, however, an explanation on how the law generally categorizes things and where those categories collide with culture. The law does not interpret meaning. It interprets objects, authorship, and claims. A hairstyle worn on a human head is generally not protected as intellectual property, but a manufactured product can be, a character can be, and a specific ornament design can be. The law is not deciding who owns a culture. It is deciding whether a particular product or expression meets legal criteria. Cultural audiences often hear a legal claim and interpret it as a cultural one. And this is not to say that the cultural concerns are invalid. It does, however, mean that they are being filtered through a system not designed to resolve them. Courts do not just resolve disputes. They establish frameworks. Especially in emerging areas, early decisions tend to shape how future cases are approached. They become benchmarks, reference points, not because they are perfect, but because they exist. This is how precedent works. Courts do not rule on culture, but they do rule on claims. But once a framework is established, creators start to adapt to it. Some will narrow their work to protect it, and others will expand theirs to avoid restriction. Culture adjusts. The deeper question then is not who wins a case. It is whether the system built around ownership can coexist with traditions built around inheritance, and whether shared visual language can survive once recognition, protection, and income depend on exclusivity, and whether translation into legal and economic terms preserves culture or slowly redefines it. These questions do not have clean answers, unfortunately, but they are worth asking. Because what is being negotiated here is not just a hairstyle or a product or a brand. It is how culture continues once it is required to speak the language of ownership. Thank you so much for tuning in to Melanin Archives. I'm very interested to hear your opinions down in the comment section below, and I'll see you in the next one. Shalom, shalom, and most importantly, shalom.